Welcome, Advocates for Justice Paralegal School. I'm Coach Neighbors, and we got some stuff to talk about today. Welcome to Advocates for Justice Foreclosure Defense Paralegal School. Oh, did I say that already? Okay, I'm going to say it again. Welcome to Advocates for Justice. Okay, sorry. We provide the tools, and you do the work. I'm Coach Neighbors, and tonight we're going to update you. Not really update you. We're not adding anything to it, but we're going to update you on how to state a claim for relief. That is what they're trying to use to get by on all of our packages. And, according to the rules, if you have enough facts in there, you shouldn't have to do the state a claim for relief. But we already know which part of the rules they like to follow. And since they're the ones that made the rules, we just have to figure out a way to make them work for us. So if you invested in one of my lawsuit packages, I made an updated video I'm going to post tonight, and I'm also going to kind of go over that video, the information in that video right now in a couple of minutes about how to state a claim for relief. And really, so what you guys are going to need to do is you're going to need to review how to state a claim for relief and use that when you personalize the documents and put your information in it. You'll have to connect your information to how to state a claim for relief. If that's how they want to play it, then we'll figure out how to get that done. So that's what we're going to learn how to do. Right now, I think in most of what I've heard, the replies I've heard from people, that's how they come. How to try to dismiss your stuff or failure to state a claim for relief under Rule 12B. So you guys are going to need to learn that Rule 12B inside and out. And what we're going to go over tonight is just a short, like a cheat sheet with just the information that you need to have beside you when you're actually personalizing it, so that you can make sure that you're doing all of the steps that's in the rules that they want to make us follow. So that's what we're going to get into tonight. Then you guys, so if your lawsuit got dismissed for failure to state a claim, you must review how to state a claim for relief in the video or what we're going to do tonight, and make your changes to the document and get the document filed. The court, a lot of times I've heard, not a lot of times, I've heard from people firsthand that the court uses this to help them kind of get by. So you guys are going to need to learn this, how to state a claim for relief, so that you can argue it inside and out. And you guys, and then, so a lot of times the court will tell you, the judge will tell you, oh, if you dismiss your stuff, it's dismissed and you can't file it again, or it's dismissed with prejudice or whatever. And it is if you let it be. At the end of the day, everybody gets an opportunity to do one amendment before, and this is what the Federal Rules of Civil Procedure says, before you get jammed up, you get an opportunity to amend. And that's how the process goes. When you file a claim, they get to answer, and then you get a chance to reply before the judge or anybody from the court gets involved. At least that's the way it's supposed to be. A lot of people get themselves jammed up because they file their stuff and they go sit down and wait for the judge. And if you're using my stuff, that's not what you're supposed to be doing. You didn't watch the instructional video. I'm just saying. But they go sit down and wait for the judge to rule or whatever, instead of following through with the process. And the process is what you learn when you watch the instructional videos. There's a ton of information in the instructional videos that's posted on my instructional video playlist and my YouTube channel. Now, I also posted a button on the front page of my website. There's a button there that'll link you right to the instructional video playlist. I'm learning how to do some of these things to make it easier. Now, I know I tell some of you people, my job is not to make it easy for you, but to make sure you're learning, because you're in the school now and there's nobody to hold your hand. I know. But I still try to make it easy as possible for you to access the stuff that you need to access. So I'm learning how to do a better job at that. There's a link on the front page of my website to the online course at teachable.com, to the online courses, plural. There's one for judicial and one for non-judicial. And there's also a link on there to the instructional video playlist on my YouTube channel. You can go to my YouTube channel and you can search for the instructional video playlist. And then when you open up the instructional video playlist, you have to match the titles to the title of the package that you have. And then you open up that package and you open up the video, and I'll be talking about the documents in that package. If you open up the video and it doesn't seem like we're talking about anything, or it's not making any sense, then maybe that's not the right video or something. Now, the confusion that people are having on the videos, all of the videos on my YouTube channel are not instructional videos. Most of them are training videos. The instructional videos will only be in the instructional video playlist. Well, that's the best place to find them, in the instructional video playlist. All the other videos are training videos. Those other videos are not for the people who are just getting in. Now, with that said, the other videos are for you to educate yourself and learn. But you can't use all of that stuff in the instructional video, okay? This stuff over here is for people who already been in the program, already in the ring, have been punching and getting some stuff done. Now, some of that stuff you need to know to make sure that you're putting yourself in position. But I have people getting themselves tied up, worrying about all of this other stuff and all these other videos and not what's in the instructional video. So you need to work from the instructional video and stay focused on that to get your foot in the door, to get your stuff lined up. And when you get these things done, then you can start being a little fancy-dancy doing some of this other stuff. But this other stuff is not going to help you now until you get your foot in, until you get your butt in the ring. So that's pretty much how that works. So even if the judge tells you you can't file this or you can't do something, file it. Make them, and you see where I'm going with this. Anytime the judge tells you to do something, and I'm just going to throw it out here, unless he says or she says that you're going to be held in contempt of court. And even then, like in my case years ago, it was worth it for me to push the envelope and take the punishment. So, and that gave me an opportunity to learn what we're learning now. So this is always something good that's coming out of it. But that's the thing. You never want to do what the judge says or any bar member says. For the most part, I haven't seen that work for anybody. I've seen a lot of people that now had attorneys. Okay, let me move on. So if you are in the process of personalizing your document, then you're going to need to stop and you're going to need to study this how to state a claim video that we're making tonight. The stream, it's going to be a stream video. And then there's also a new video that I'm posting that's a lot shorter than the other videos. That's more specific on getting this done, on stating the claim. Now, while I'm thinking about it, I'm also going to post the cheat notes that I put together for this on my blog site. So on the blog site is connected to my website at winandcourtnow.com. So you can go to my website, go to the blog page. Well, I haven't posted it yet, but I'll post it later tonight. And you can go to the blog page and you'll be able to copy and paste the notes, which is what we're going to go over here in a few minutes. So you'll have them that you can print out and put next to you while you're working on your document. So this is something that we all need to do if you invested in the package. Now, I left it so the package is designed where you add your stuff. And so that's the way, we've been doing it. But now they want to be complicated, so we can be complicated too, because when you see what we're talking about and you learn it's not that hard. A lot of times I'm going to say we When I say that, meaning I to get wrapped up in the facts and emotions and stuff and think that it needs to be more complicated than it needs to be. So, good evening, Edith. Welcome to the show tonight. So we're just going to keep rolling here because this is going to take a minute. So stating a claim for relief. Oh, before we get rolling, you guys make sure you go to my YouTube channel, or while you're on the channel, or go to the channel if you're coming in from Facebook. Go to the channel and subscribe to my channel. Click the button, ring the bell so you get notifications. Leave a comment, hit the like button, do all those things that, I have to say every day. You guys should know those things. Are you saying them with me? Okay, let's go. We'll get from it. Okay, never mind. Sorry. We're going to get rolling. So, pro se defendants will often file a motion to dismiss or fail to state a claim under Federal Rule of Civil Procedure, Rule 12b-6. Rule 12b-6, in part of the Federal Rule of Civil Procedure, Rule 12b, which states in general that defenses should be put in the defendant's answers, but it also gives the defendant opportunity to raise some defenses by motion before filing an answer. Now, what I did before was filing the jurisdictional challenge with an affidavit as the answer. Everybody wants me to say answer. Do I need an answer? We're worried about their program. Guys, switch over. What you filed is your answer to them. And to keep it simple, what we're learning how to do, and this is not in the instructional videos that for the judicial and non-judicial, because those were made a little while back. What we're learning how to do is we're learning how to add your claim that you're going to file in federal court, change the title heading or whatever at the top, add the judge and the attorney to it if you're in court already, because they don't have an injured party, so the judge doesn't have jurisdiction to even be doing any of this stuff. And foreclosure statute is not valid law because it doesn't have the three elements, blah, blah, blah. So add those things and file that in their case as a counterclaim, so you don't have to pay. In most places, you don't have to pay to file a counterclaim in a state case that's filed against you. Now, when they tell them, oh, you can't file a federal in the county. No, I'm not filing a federal. I'm filing a counterclaim in their case. Now, you're doing this just to blow up their case by the time you add the judge to it, you add the attorney to it, because they're the only names on there that's trying to take your property. Nobody from the bank has signed anything. Only the judge and the attorney is pretty much the people who signed. And that's why you're going to be adding them. Keep it simple. They're the only ones that sign. So you're adding them. And by the time they figure out what they need to be doing, you're going to be filing your lawsuit in federal court. And then once your lawsuit is filed in federal court, you can move that stuff over there, over to be connected to your as evidence. You use the federal stuff, the state stuff to connect to your federal stuff to show what they were doing. Now, this is the attorney standard process that they put together that they want you to follow how to state a claim. You guys should know now that you need to study the Federal Rule of Civil Procedure, Rule 12b, and know it inside and out. And when you go to my website, blog page, and get the cheat sheet, you'll have it delayed next to you when you're filling out when you're putting your personalizing your document. So now defendants can, instead of answering right away, raise one or more Rule 12b defenses by motion. And only if the defendants lose, that motion will have to file an answer to the complaint. So a lot of people get this mixed up because, I'll be telling them, oh no, but I got to answer. No, you don't have to answer. You don't have to file a Rule 12B motion to get out of answering either. If you challenge the court's jurisdiction to proceed, but attorneys are not going to mention that any place. And that's why I like to mention it, so that you guys know. And that's what we do. But we want to make sure that we're doing it the way they want to complain about. We're not. Because if this is all they got to complain about, we can change this and make this work. So one of the reasons Rule 12B allows you to raise motions in the defense out of Rule 12B6 and failure to state a claim upon which relief can be granted. Now, if the defendants win, the case will be dismissed, and then you will have to appeal to get your case reinstated. So, you know, and you got to understand too that they're going to go with the odds. They always do, because they used to always win. Without the internet, they would still be winning. But now things have been a little even out with the internet. So they're going to go with the odds. And even if you perfectly state a claim for relief and your stuff is absolutely perfect, they're still going to lie to your face and tell you that it's not, so they can get you beat down. That's how they do it. And if anybody thinks that's different, let me know. Because I've been there and I've seen it. So first we need to go, what is a claim? To defend against a motion for failure to state a claim upon release can be granted, you must first understand what a claim is under the Federal Rules of Civil Procedure. So under the Federal Rules of Civil Procedure, a claim is for relief as defined under Rule 8A as having these three elements. The first element, and not the most important one, the second to the most important one. The first element is a short and plain statement of the grounds that provide jurisdiction to the court. Okay, and the attorneys will tell you that's the most important one, but I don't agree. So they have it first. The second one is the most important one, in my opinion, is a short and plain statement of the claim showing that the pleader is entitled to relief. And the third thing that you have to have in there is a demand for judgment for the relief the pleader seeks. So you can see these things are personal kind of things. You know, the personal information has to be put with these things. So we're going to get the program figured out so you guys can do that. And then we're going to see what else they want to bring to the table to try to get out of being held liable for what they're doing. Now, what this means is that the complaint needs to contain statements that support the federal court's jurisdiction. For example, that the case was brought forth to enforce constitutional rights under 42 U.S.C. 1983, or something like that. And that's one of the things that is missing from, we're not real clear on that, but we're going to learn now how to be more clear on that. The statement must have allegations of fact that support each claim that's being made and the request for relief. Now, the policy behind these rules supposedly is to simplify the pleadings and not to put up technical barriers to relief. The most important part of Rule 8A for the purpose of Rule 12B6 motion is the second part, the short and plain statement of the claim. And I don't understand why that wouldn't be listed as first at the top when they're saying it's second. But I'm going to tell you straight. This means that the plain statement of fact that make up the claim. For example, you must put in a statement that shows what happened to you, that you were seriously injured, and the mental state element required by the courts, and that the defendant acted with deliberate indifference to the Constitution or whatever law that you're saying is. And most people miss out on that last one, the deliberate indifference statement. And without that statement, If you fail to put the delivered and different statement in your complaint, it'll be dismissed for failure to state a claim. It'll be dismissed for failure to state a constitutional claim. You must make sure to make specific allegations of fact. Who did what and when. And that is one of the things that we're going to change in our document, because most of the time we can add those facts in because they're pretty much all the same if you look at it. Now, if you're going after the 42 USC for the court process, and it'll be real easy to make those changes. So you want to avoid conclusions. Also, be sure to include how you were injured by what the defendant did or the defendants did. A lot of times people leave out the emotional suffering that they watch their family or kids or spouse or parents or neighbors in some cases go through. Those things count. And you also need to have the fact to show how the defendants violate their constitutional rights. And I would make sure that I put in there on the violating the real estate deed laws, because violating the real estate deed laws is what this is all about. Everyone is specific. Oh, I'm in foreclosure. No, I'm in tax lien. And you are, but the problem is that your deed is posted in their office and they committed real estate deed fraud by not delivering your deed to your house as mandated by the property transfer laws in your state. They did what they call their constructive delivery, and they registered in their office. And once that deed was registered, it allowed all of these people to start putting liens against your property. As a matter of fact, once the deed was registered, the very first lien against your property was placed on your property. And most people don't realize that the very first lien was the illegal mortgage lien. I know people think I'm crazy, but think about it. If there were several people who own property, all of those people would have to be present to sign a lien against that property, right? Yep. So the fact that the alleged lender accepted your signature on the mortgage lien against the property shows that, and you were the only one that was expected to sign, or you and your wife or whatever, shows that you guys owned it already. So, and that's what I usually shout out these haters on Facebook when they want to start talking crap, because that's keeping it simple. When you keep it simple, there is no room for arguing. So if you have included in your complaint the jurisdictional allegations, the facts of what the defendants did, allegations of deliberate indifference or other necessary mental states, and a request for relief, monetary damages, injunctive release, whatever, then you stated a claim. So you need to study these to make sure that you have this lined up even before you go to the table. If you went to the table and it got dismissed, then you can go back to the table. If it was time, but then you can still go back and bring this to the table or file another claim or whatever you need to do. So the standards for Rule 12b-6 motion. Courts do not generally favor Rule 12b motions to dismiss, because the policy of the federal court rules is to allow the case to proceed if the plaintiff has any reasonable chance of obtaining relief. So defendants are required to make a strong showing before a complaint can be dismissed for failure to state a claim. Now, that's what the rules say, but we already know that how this really works. So what is a strong showing? But that'll take up another whole hour. So we'll stick to this. So a Rule 12b motion argues that based on what is said in the complaint, the plaintiffs could not possibly be entitled to relief. Courts do not determine whether the facts as stated by the plaintiffs are true, but instead assume the truth of the plaintiff's factual statements and decide whether you may have a claim that could lead to relief. Now, in the U.S. Supreme Court, they've stated the issue is not whether the plaintiff will ultimately prevail, but whether the claimant is entitled to offer evidence in support of the claim. So that's what we need to be saying in the end. You have proved that you are entitled to offer evidence in support of your claims. And then they need to have a court set up so you can get the evidence that you need if you don't already have your court docket sheet from state court. That's what we're going to be using. A complaint should not be dismissed for failure to state a claim unless it appears beyond a doubt that the plaintiff can prove no set of facts in support of his claim, which would entitle him to relief. And that's a case law on the Clooney versus Gibson. And dismissal without leave to amend is improper unless it's clear upon de novo review that the complaint would not be saved by the amendment. Snyder versus California. So that's what we're going to talk about tonight, guys. I want you guys to go to my website and copy and paste the notes from what we're talking about tonight. So you'll have the cheat sheet you'll be able to use next to you while you're working on your claim. So that's all the value I have to share with you guys tonight. I will see you in the next stream, and we got a new video that's going to be posted tomorrow also. So you guys should check it out. Thank you, and see you in the next live stream.